Good afternoon, dear friends. We begin our strategic session on lifting the corporate veil and redrawing the limits of responsibility. Who is the real winner? First, allow me to introduce to you the participants of our today's discussion. Alexei Kuznov, Director of the Legal Department, Bank of Russia. Ilya Polyakov, Chairman of the Management Board, Rosbank. Yuri Isayev, Director General of the State Corporation Deposit Insurance Agency, and Alexander Sokolov, President and Chairman of the Management Board, Trust Bank. Indeed, starting from July 2021, credit organizations, insurance companies, pension funds have to submit to the Bank of Russia information on their controlling parties and the regulator has to identify financial institutions' ultimate beneficiaries, and it has to place that information on its website, and this seeks to lift the corporate veil. The new law will allow to identify ultimate beneficiaries and also find who really controls this or that company to ensure subsidiary responsibility. This idea is not something absolutely novel, but this law is the next evolutionary step in that regard, and it helps the participants of the financial market to reach a new level of responsibility. And of course, for everyone and for controlling parties, the law introduces several new criteria, several new responsibilities. But before we move on to a Q&A session, I would like to propose that everyone who has joined us should participate in a poll. Could you please put it on the screen? Will the law allow reaching the goal envisioned by the legislator? And we will take stock of the outcome after the first round of questions and answers. And you can see the question both in Russian and in English. Don't be shy. Give your answer to this question, and there are several choices you can make. Yes, no, I'm not sure, I cannot answer this question. Now, let's move on to the discussion. My first question will go to Alexei Kuznov. Mr. Kuznov, what do you think? What are the most important novelties brought about by the law, and how far, to what extent, will they allow to improve the procedure for holding the controlling parties accountable? And I would like to remind you that we can provide you with up to 5 minutes to give an answer to the question we ask. Yes, thank you very much, friends. You are absolutely right. This is not something novel. Even here at the IFC, this question was discussed on several occasions. But, you know, the legislation has been evolving, and we have to place the law into the context, because for the last 2 decades we've been working on improving the legislation. On the one hand, this legislation has always been trying to identify more accurately the ultimate beneficiaries, the controlling parties that have a bearing on the activities of this or that financial organization. At the same time, we were trying to establish the responsibility, in particular property responsibility, of these controlling parties. The whole legislation of this financial regulations, there is something novel about that, that is the ultimate beneficiary, but we have the same notion in bankruptcy law. Maybe there is a novelty in that, apart from the criteria which we see in the bankruptcy law, the legislator has also suggested using the control and important influence criterion, which goes back to the international financial reporting standards. But the thing is, it has already been used when assessing the risk of borrowers and all that. Information in disclosure, this is not something new either. And even the structure of ownership, the issues of securities, banks, everyone has to disclose that information. Information disclosure is a criterion to get access to the deposit insurance system. There are also requirements with regard to non-government pension funds and some other institutions. There is a novelty in that the Bank of Russia has the power to add additional legal entities to the list based on its own criteria. But this is due to the fact that between a controlling party and a controlling organization that is being controlled, there can be a certain conflict of interest, and overcoming that collision of interest is something that falls now within the remit of the Bank of Russia. This list of controlling parties is public, but there is a procedure for administrative appeal, and it's a procedure that is well known to the banking community, in particular in terms of the financial regulation. When the reputation of this or that person is being assessed, and when there is negative assessment, you can be introduced into a list of those who cannot be nominated for such important positions. So this procedure already exists. And also, apart from the administrative appeal, there is also a court appeal that is possible. And over the recent years, we have seen this practice emerge. Courts also give their own rulings on such cases. That's the first part. And it shows us how we can better identify the ownership of financial organizations. There is another track in developing our legislation. It is related to financial responsibility, liability, and there is a logic behind it too. I remember when bankruptcy legislation was established, there was a reference norm. It was a reference to the principles of civil legislation. It said that a participant of society was not liable for the debts of the legal entity he or she participates in. Right now, it's different. We have legislation on the rights and responsibilities of controlling parties. We have also reinforced our deposit insurance legislation. I do hope Yuri will have a chance to talk about that in greater detail. Probably there is a new thing. The thing is, the law does not just seek to hold controlling parties liable in terms of subsidiary responsibility, because, it's limited. Such liability only happens when the procedure is almost over. But all institutions introduced by the law seek to ensure property liability when damages are compensated. This court practice is already emerging, both thanks to the efforts of the Bank of Russia and thanks to the efforts of Deposit Insurance Agency. Alexander Sokolov, who is with us, knows that, and we work, and there are several processes that are ongoing, and the approaches have already been elaborated. I believe that the legislation seeks to raise the efficiency of holding people accountable. Because behind these instruments, there is possibility to block very fast the embezzlement or the sale of assets, thanks to special provision and measures. But that's what we see on the surface. If you dig deeper, then you'll see that this mechanism seeks to prevent irregular behavior by controlling parties in the financial markets. Thank you very much, Alexei. As a follow-up to what you said, I would like to address my next question to Alexander Sokolov. What do you think, Mr. Sokolov? Do you think it is, it's worthwhile disclosing information and making it public? Do you think this public nature of the list of controlling parties, do you think this disclosure will raise openness, transparency, and allow to better hold people accountable? I think, yes, thank you. I think it's worthwhile. I think it's justified because we seek to create an honest business environment in our country. If you've got nothing to hide, so what can be the problem with publicly disclosing that, yes, you are a beneficiary of this or that business? What's the problem with the regulator disclosing on its website that apart from the management, there are also beneficiaries of this or that company, be that a legal entity or a physical person? So my question is unequivocally yes. At least this new norm of public disclosure is going to render more difficult for those business agents who are not acting in good faith. The conduct of their activities and businesses. You see, any economic agent that seeks to make money, to make profit, will always try to follow the shortest path, the least expensive path of making money. And if this path is cheaper and easier, provided that you break an ethic codes or some laws, then unfortunately this is always going to be the case. This path is going to be always chosen by these business agents. So my belief is that we have to make illegal business too expensive. It has to be more expensive than the honest path. And then we won't have to use the truncheons of our police and enforcement agencies to make everyone keep in line. I think this is also an instrument that will help us use legal, non-violent means to prevent corruption, to make our businesses honest. And I think we have to go in even further. And this public disclosure in future should apply not just to financial organizations, but to any other organization that works with borrowings, with borrowed money. So this is but a first step, because, yes, this sector is most prepared. It's boasting of the highest level of financial literacy, but I do hope that this practice of disclosing information on ultimate beneficiaries will further expand and cover other sectors too. Yes, thank you, Mr. Sokolov. So if someone doesn't want to live an honest life anywhere, we're not going to make life any easier for them. We are going to create an environment that will make it easier to do honest business, however. So how is market responding to these novelties? I would like to welcome a colleague of mine, Ilya Polyakov. Hi. My question goes to you. What do you think about our market? Do you think it's ready for such openness? Don't you think that there's going to be an opposite reaction after these novelties? You know, as they say, if a new law comes into existence, always ways are found to circumvent it. Don't you think that new schemes will emerge to obscure and obfuscate real beneficiaries? Don't you think that an even more complicated, more opaque corporate veil will emerge? Yes, thank you very much. It's a pleasure to meet you, even though online, not in person. But still, it's a pleasure. Before joining this conference, we talked with Yuri Olegovich about these new approaches In the past, it was impossible. Even now that we both are in a business trip, we managed to join this panel in the course of this year's IFC. In response to your question, I will say that I don't think that this will exacerbate the situation, because there is no way back, as a matter of fact. Right now, we see such a state of affairs that it is all but impossible not to disclose this information on ultimate beneficiaries. This law serves as the last element of creating this openness system. You know, I represent a bank that is part of an international group, and in that capacity I support this road towards greater openness. I believe this legislation gives us a greater level of transparency, and this is also something we wish for our clients, for all the stakeholders, and for our investors. I think this is only natural, moving in this direction. And as has already been pointed out today, this is a follow-up to what we saw done in the past. Probably the most important element of this new law is, Alexei has already provided us with an overview of the most important novelties. He has explained to us what this law is about, but I think there is a very important element. Our regulator right now has the power to take preventive actions, and one of the most interesting novelties is the possibility for the Bank of Russia to act proactively. Say if there is negative capital, and the Bank of Russia gets additional rights to take action, and such a situation, instead of simply waiting for this company to go bankrupt, it is also very important that the legislation provides clearer sets of rules. And we now see rules on establishing these lists of credit organizations. And even if this or that organization runs into difficulties, it will not going to take us a whale of time to find who the controlling party is. So it's all going to be more efficient and more transparent. And I would like to join Mr. Sakharov in saying that I do hope that these rules in future will expand and will also cover not just the financial organizations but also other participants of the market. I do hope that they will apply to other legal entities, which will harmonize even greater our requirements and international and Russian standards. As of now, international standards on disclosing ultimate beneficiaries are stricter, and we try to stick to these standards everywhere in Russia too, but sometimes it creates certain competitive disadvantages to us, because there are other players in the market in Russia that are not sticking to those strict sets of rules in disclosing ultimate beneficiaries. I do hope this law is going to be a precursor of a new practice when such norms will be expanded to apply to everyone, and our clients and society as a whole will stand to benefit from that. Thank you very much. You know, I find myself together with Yuri Olegovich on one panel. Yuri, you have a very rich experience of working with credit organizations, in particular organizations that have gone bankrupt due to the circumstances. So what are the difficulties you're experiencing in that regard? Do you think the new law will help address those problems, those issues that you encounter on a regular basis? Good afternoon, colleagues. Mikhail, thank you very much for providing me this opportunity to speak today, to speak on this theme. I would like to say that this theme is of great importance to the Deposit Insurance Agency. to be honest, we were the first organization in Russia that raised the issue of lifting the corporate veil, the corporate cover. It was in December 2012 during the Intergovernmental Group session on preventing illicit financial operations. And our proposals back then to improve this legislation did not garner any support. We were dubbed extremists, as it were. But this extremism of ours, this radicalism, as it were, is based on our deep knowledge of what is happening in the market. For a very long time, our agency has been working with insurance companies, with banks, with pension funds. Half of these procedures have been completed, others are still ongoing, and we conduct controls and inspections at all these organizations. We try to assess the financial component and all the rest, and unfortunately our inspection reveals that in most cases the main reason for bankruptcy and lack of assets are explained by illicit actions by either ultimate beneficiaries or managers. In 80% of cases, we see a criminal element. There is premeditated bankruptcy, and we also face illicit withdrawal of assets from the country abroad. And over these years, we have managed to establish a well-ramified practice of holding managers and beneficiaries liable and accountable for such bankruptcy. And right now, what's at stake is 2 trillion rubles. There are 470 appeals to the court, and the court rulings will amount to more than 1 trillion rubles, and some of the claims are still being considered. And there are also 740 criminal proceedings that have been brought against, and a large chunk of that is beneficiaries. 220 beneficiaries or managers have been convicted. Last year there were court rulings on 52 court proceedings we've been following, and some people got real sentences. And honestly, the faster we are capable of identifying the controlling parties whose actions led to bankruptcy, the greater the probability is that we will be able to arrest the assets which can be used in order to satisfy the creditor's claims. And I would like to point out that the law that has entered into force has provisions that will raise the efficiency of holding beneficiaries and managers civilly liable. We've spoken about this list compiled by the Bank of Russia, and this status of controlling party with regard to a plaintiff and the case, this is probably the most important part, the onus of evidence that shifts onto us, and collecting evidence on controlling parties is often rendered very difficult. Everyone probably remembers Mr. Pugachev, he never put his signature, he put a stamp saying agreed, and in the letters the employees couldn't even address that person by his name. So the collection of evidence was very difficult. And there is another thing, that is the asset recovery. Even if there is a positive court ruling, if there is a conviction, that does not always mean that the money is going to get back, because assets can be dispersed across different jurisdictions, they can be obfuscated by the corporate veil, and sometimes it's almost impossible to recover assets in Russia. And as we know, very often the law enforcement simply cannot catch these people. They can leave the country before that.
Most important is how quickly you can impose restrictions, and the new law allows for that. But it's a new piece of legislation, and I'm sure it will help enhance transparency of the market.
Спасибо большое, Юрий Олегович. Я вижу присутствующие, все, кто и виртуально, и реально с нами,
all participants online and offline are united in thinking that it's a good law, should improve the situation. But let us compare notes on one more point. Let us poll our audience.
Давайте покажем результаты проведенного в начале опроса.
Or rather, let us check on the results of the poll. So, what's your view? Will the law help or not? Will it help attain the goal of the legislator? 54% is over half, and said yes.
Большие цифры. Но, коллеги, давайте обратим внимание на то, что примерно треть,
but let us know that about 32%, about a third, have doubts.
Не поможет, да? Еще 12%
Think that probably not, and 12% are not sure.
Наличие и уверенности в том, что будет
generally
лучше от
people are
этого закона, и
hopeful,
наличие некоторого скепсиса определенного, и
but
количество таких
some are skeptical.
тоже приличное.
About 1/3 of people are skeptical. Well, let's live and see. Let's touch upon one more interesting question. About liability, sharing liability, and who's going to win? Should a trigger event take place? Supervisory bodies
и они могут быть привлечены к субсидиарной ответственности, а их средства могут быть заблокированы. И в этой ситуации особое значение приобретает добросовестное раскрытие информации о контролирующих лицах.
So, about beneficiaries. So, disclosure of information about beneficiaries becomes important. So, going back to Alexander, I want to ask you a question. What do you think? When identifying a beneficiary, is it possible that an internal conflict would emerge where not all beneficiaries would be prepared to lift the veil? Financial institution naturally will be held liable for complying with existing legislation. But who in particular, on behalf of this financial institution, is entitled to identify a list of beneficiaries, and who should be responsible for providing information about beneficiaries to us, meaning the Bank of Russia? We don't have much time, so please limit your statement to 3 minutes max. Well, as regards potential conflicts, of course there's potential for conflicts. I don't think all economic agents will welcome this new law and will be happy to disclose information about beneficiaries. We're likely to face opposition, to see, double veils, triple veils, but who should be held responsible for failing to lift the veil? Well, executive bodies of a legal entity will be held liable, apparently. In the first place, CEOs, top management. In a perfect world, if we think of the evolution of this law, we need to think of
последствия или ответственность за нераскрытие своей возможности контроля.
Implications or failure to disclose information about beneficiaries.
Но и на самих бенефициаров, потому что это должна быть.
That should be not just with top management of a legal entity, but with beneficiaries as well. It should be a two-way street in a sense, because we've seen cases where actual beneficiaries would make top management do certain things.
Предприятий, которыми они управляют, иногда
Management
даже где-то против воли прям
companies,
заставляют.
like force them. We've seen it.
Сейчас еще раз это бремя ответственности
So
ляжет
today,
на руководство
under
организации.
this new law, top management will be held responsible, but in the future we need to think about information. We need to think of holding responsible not just top management, but also beneficiaries once they are identified.
Система штрафов.
Maybe a system of substantial fines needs to be introduced to make it economically unjustified, to make it really expensive to refuse to disclose both for companies and for beneficiaries. Well, you understand that when the CEO refuses to disclose beneficiary, how can we punish the beneficiary? How can we hold him responsible if we have no proof? So CEOs will probably be held responsible, although we understand that beneficiary owner might shuffle CEOs. But we need to start somewhere, so let's start there. Alexei, I have a question for you. This new law recognizes as beneficiary not just someone who controls a company at this point of time, but also those people that controlled it in the previous 3 years. 3 years is a long time, I should say, and a lot of change might happen in how this financial organization works and operates. For instance, because the beneficiary might have changed. So do you think this norm, this novelty is justified? It's not a novelty. The existing bankruptcy legislation, when identifying beneficiaries, it defines this time as 3 years. Someone who was in charge for 3 years is considered to be in control. So the big question is, what are the actual processes happening within this financial organization? How they're assessed, how they're documented. Now already, as we look at whether this or that person can formally be nominated as beneficiary, for instance, it could have helped prevent a negative scenario that led to actual bankruptcy. We'll look at decisions that were taken, and we see how management of a company was organized. And in many cases, we see that there are people that would tell owners, for instance, that this would be a mistake, don't do that. Structure management differently, rethink your lending policy. And I don't think those people should be held responsible for anything. They should rather be acclaimed for their professional work. And I want to argue with the previous speaker, who said that CEOs should be held responsible for coming up with a list of beneficiaries. I think there is balance in this decision, because there are mechanisms to overcome conflict of interests between the financial organization and the beneficiary that does not want to be disclosed, because the Bank of Russia has the competence to identify those people and to put them on the list that is published, no matter what the organization provides as a list of beneficiaries. Let's ask Yuri. If a CEO is silent and refuses to disclose beneficiaries, and what if we as the Bank of Russia know or can guess? So this new law allows us to identify beneficiary. But will you be comfortable with this practice? What if we tell you that Mr. Ivanov is the beneficiary owner of this organization? Will it help you in asset recovery, for instance? Well, of course it will. And that would be a very good decision that we'd welcome and endorse. Bank of Russia, as regulator, provides supervision for all areas of financial market. So giving regulator competence to recognize people as beneficiary owners of legal entities makes a lot of sense. I would say even that this is the only viable option in this situation that genuinely reflects the global best practices, where regulators keep an open or a classified registry of beneficiaries and demands that banks disclose the entire management and ownership structure. And information about nominal beneficiaries should be supplemented by information about beneficial ownership. In the EU, there is a directive aimed at preventing using financial system for money laundering or terrorist funding, and it contains all these norms, including keeping a registry of beneficiary owners. Such registries exist in England, Germany, Belgium, Netherlands, Luxembourg, certain Baltic states, and Malta. And there are countries that are planning to introduce such registries in the nearest term. Hungary and France. France does not have this registry at the moment, but the regulator already today requires that regulators disclose this information on their website. Great Britain, the financial behavior division of the Bank of England also keeping track, and if you fail to provide information, you can be held accountable. In Austria, they also have this registry, although it is classified. This registry exists in Australia. I mean, it's an established best practice globally, so I think it's a welcome step. But the big question is what happens if there's a discrepancy between registry and real life. So to sum up, yes, it will make our life easier. And for Russia, where the central bank is a mega regulator, the decision to give him these competences makes a lot of sense. It is a lot of responsibility for us. I mean,
не будет таковым. Но мы вот давайте развернем нашу дискуссию немножко в
we don't want to be mistaken and nominate someone a beneficiary owner when he's not. So let us change the subject. We spoke about regulators, those that collect debts, but I have a question for market participants, Ilya in particular. Do you see a positive side of this regulation? Do you think it might get better to live in plain daylight, not under this corporate veil? Do you see advantages potentially? What do you think? Is there anything good? Not much time again, so please be brief. Well, provided management of the Bank of Russia identifies beneficiary owners correctly, everyone should win, including banks themselves. First, banks will not have a choice. Those that try to conceal or that will fail to disclose all information, they will not be able to compete with transparent banks. And also we'll see certain solidarity that all financial institutions will have, because the reputation of the financial sector will very much depend on the position of each and every bank in particular. And when scandals happen, that hits banking sector in its entirety and undermines confidence and trust in clients. So the banking sector will win if confidence is built. Of course, there'll be more administrative burden for credit institutions because additional reporting will be required, but taking into account all benefits, I wouldn't say this negative impact is that significant. Thank you, Ilya. We're getting questions from the audience, from people that are watching us online. One of the questions is, why is pre-trial appeal procedure needed? Why is this commission needed? Can you ask it? Well, to protect rights of people, because many decisions are taken on the basis of the decision of the committee. And it's based on professional judgment when we identify beneficiaries. Do we anticipate that potential beneficiaries will try to appeal being put on the list? Imagine we put someone on the registry and people try to appeal it and take things to court. Do we expect litigations? Well, we expect separate cases of litigation, but not many of them. So we're talking about establishing a legal fact, not liability. Maybe Yuri or Alexander could answer another question from the audience. From your practice, is it realistic to identify beneficiaries if they're residents of foreign countries? And are there any established mechanisms of cooperation between regulations from different jurisdictions to identify beneficiaries or to check information or evidence that you're getting? We do that on a regular basis, both domestically and abroad. And it's easier to do that abroad, actually, because the court system has established court practice. So it's real, it's operational, it's an instrument that is well established in advanced economies, and we will be able to make it operational. One more question from the audience. Will this law push owners that are already on the last breath to give up their businesses altogether? Is it likely to happen that once this law is put in place, people would just withdraw from business? We haven't seen that many cases where people would give up on their licenses, not on the Russian market, but probably this law will result in a growing number of such cases because competition on the market is growing. In Russia, there are still many banks for the size of our economy, so it might happen, but I don't think we should expect many, rather individual cases. Alexei, you said that back in 2015, you came up with this suggestion. And some said that you were too harsh, and there's a question from the audience. Had this law been adopted earlier, do you think we could avoid problems we encountered, raise efficiency? Should it have been taken? Should it have been adopted earlier? Well, had it been adopted earlier, I'm sure we would be able to deal with many problems in a more efficient way. That's pretty obvious. Well, thank God we're finally there. And a pilot phase, the trial and error will take a couple of years. So, of course, it would be good if such needed legal instruments could be introduced faster. Well, we're almost out of time. We don't have more than 45 minutes left. So I would like to ask our panelists to very briefly answer the following question. 1/3 of our poll participants have doubt that this law will be useful. What do you think? What is it you would change in this legal instrument? Is there something missing? Is there something that should be different? Should it be amended? No, I wouldn't amend this law. Let us check how it goes. As for legal framework generally, it needs to be amended. State Duma did not pass another piece of legislation that was regulating potential departure from the country for those beneficiaries. Alexander, what would you say? Well, I'd also say let's make it operational and see how it goes. Let us collect feedback and then decide what change is needed, if any. As regards future evolution, like I said, I think we need to consider additional responsibility, financial liability, not criminal, but financial. Because we don't want people to land in jail. Many already have, too many. So, system of fines and liability should evolve. We should make it expensive to break the law. Ilya, do you think the law could be improved? Well, I'd say it's a very good piece of legislation. My only wish is to see it applied in practice as it was designed to. And probably this is what people, the 30% of the audience that answered no, have doubts precisely about that. We need to make sure that the law is applied properly. Back in 2015, you were ahead of everyone with your initiatives. Do you think you could set a new target for us? Or should we wait and see how it goes? Well, I think we should wait and see how it goes. Let's look at how our court system responds. So we probably need time to see how those norms apply in real life. And then we'll see what steps we'll need to take. And I agree with previous speakers that we need a law to limit the ability to leave the country. Don't call me extremist for that, but in conclusion, I want to say that we need that, judging from experience. Well, for obvious reasons, because of the pandemic, no one can leave this country, basically. So, pandemic made up for what legislation failed to achieve, but we probably need to continue working in that direction. We only have 1 minute left, so I want to use this time to thank you, dear colleagues, for finding time to join this discussion. We did not have much time, but I think we were able to cover many very relevant issues. We had very enriching discussion. I want to thank our audience for their time, for their attention, for many good questions we received. Unfortunately, we didn't have time to cover all questions that we received. But I think you understand the general trend.
не просто так этот закон появился, он был выстрадан,
There was good
в какой-то степени вымышен,
thinking,
достаточно
good
хорошо
rationale
проработан.
behind this law.
Я думаю, мы практически пришли к консенсусу, и
I think we've come to
действительно
a
время покажет.
consensus.
Давайте
So time will show.
посмотрим.
Let's
Я думаю,
wait
мы
and see.
двигаемся в
And I
одном
think we're
направлении
going
совсем цивилизованным
in the same
цивилизованным
direction
миром.
as
Спасибо за
the
ваше внимание.
civilized
Всего доброго,
world.
дорогие.
Thank you for your attention and all the